I bet. I'll tell him that you said that. He was over at Walk On working today. I wasn't sure he was going to come over.
He's coming back to work, huh?
Well, he's got his plans to fix up, you know? So, and neglects too many months.
No, my wife called.
A couple more chairs.
Find out what the...
There's a chair up front if someone wants it right up here.
You're probably another 9-0 season.
Well, whichever way you look at it, right? The bottom up or the top down. What they call Look at all kinds of chairs here yet. You want some chairs? There's chairs back here. Okay.
Thank you.
You got it. See over there? Yeah.
I don't mind.
You know, maybe what it is.
Works good for me.
He's got munchies in his pocket. I want some. What they are.
No hitting me during the meeting.
Right.
Yeah, it's always a surprise. Chances are.
Do you know the folks next to Jack, too? The folks next to Jack, you know them too? The ones that are sitting next door.
Oh, yeah. That's Chris. Nice.
That's right, you told me that. Hi.
Chris and Mark.
Okay.
Summer ball and everyone's always something going on.
He was very confident that our city was available. Better say it that way, right? Yeah. What else he gonna say? I don't know.
Oh. I think it was. Second Thursday.
Talk this through here.
Somewhere. Volleyball. There's two of them in volleyball and one in football. Junior high football. Yeah, we were just, we tried to work it out. My daughter called me when I was in high school.
Okay, I'll call a meeting to order, special meeting, have roll call.
Harness.
Here.
Bichler.
Here.
Steiner.
Here. Verification of posting.
Postings were put at the town hall, port, fire station, and emails were delivered on Monday the 16th.
Consider notice of appeal filed by Crawford County Stewardship, Arnold Steele, Mark Fisher, Warren Fisher, and Dan Linder.
I don't know if you guys have this, we'll give you a couple, I'll give each of the board members. John. Rod. That's the notice of appeal that was filed. What that is basically, there's a chapter, there's chapter 68 in the Wisconsin statutes, which allows certain individuals, if they believe they've been aggrieved by a decision by a municipality, to appeal that decision, so to speak, okay? That's what chapter 68 is for. There's a lot of technical requirements to it that I won't spend a lot of time on. But basically, that's what they have done. They've filed an appeal asking for this board to basically review the decisions of the Plan Commission to grant the conditional use permit to Patterson, and to review your own decision regarding the, I guess, the permit that was issued, the reclamation permit. Okay. What they're asking is that the board hold a hearing at which the aggrieved persons can present evidence, and the town can present evidence itself. And then basically, if you consider the decisions that were made by the Plan Commission and by this board. They have made that request, or they filed that notice. I also have, I was contacted by the attorneys who are representing those folks. They called me this afternoon and they said that Attorney Reynolds had a letter that he would like me to present to the board members. I told him I would certainly do that. I've got copies of that. I'll give each of you that and give you a chance to read through that, and then we can talk about kind of where we go from here.
Thanks.
Thank you. I guess before I forget, this is information that's just given to me to, I guess, give to the board. It's not really part of our procedure tonight. I'm not even sure what's in there, but I guess if you want to take that, you'll have that. And if the board wants to look at it at their meetings, they certainly can. You know, I guess we're here tonight to determine what to do with this appeal. I mean, I think you've got a couple options. One, we can say we're going to go forward, we're going to hold that hearing, and we're going to schedule the date for that. Okay, that's certainly an option that the board has. This is going to be a popular opinion in this room, but my legal opinion is that the board should deny the request because it's on the grounds it's not timely. Statute requires that it's within 30 days after the relevant decision is made. In this case, the decision to issue those permits were made back in March, where the request was made in September. We're well past that. I know that Attorney Reynolds probably won't agree with that. I'm sure he's going to argue that the decisions, there were actions taken back on August 14th. But I think there's the case law is pretty clear that subsequent actions simply to effectuate a permit, doesn't allow you to start the clock ticking again. Okay, so I don't think that the request is timely. Okay, and it would be strictly in providing what I believe to be, giving legal advice to the town board from a practical and from a strategic matter. Okay, my advice is for the board tonight to simply vote to deny the request for the hearing based on the fact that it's not timely. Okay, they can certainly challenge that, and I won't be surprised. They probably will. And then it's just as the other lawsuit, then the court will make that decision. And we'll go through that. I've wrestled with this. I'm very clear in my mind that it's late, that it's too late, that you would have the ground to deny that. As you know, the town's also being sued by most of these parties. There is a lawsuit that has been filed. We do have the insurance companies providing defense for the town. They have an attorney, got a firm who is representing. I have been in contact with them. Denial of this request would be consistent with what their suggestion. I guess the advice to deny the permit based on timeliness issue that's my opinion, that's my recommendation, that's what they're recommending as well for a number of reasons that I won't get into right now. But so I mean that is my that would be my recommendation to the board. You're certainly free to do what you want to do. But my opinion is that it's not timely, that you have grounds to deny it, and you don't even have to consider it because it's not timely. So, and there are a number of other issues with it in terms of whether the petition adequately sets forth why the parties listed there are aggrieved, and it can get all kinds of technical things that can kind of go back and forth. But the timeliness issue is the big one there. Statute requires 30 days, and we didn't have that here. So, and I guess to reiterate, I mean, this is consistent with this this would be consistent with what the attorney who represents the insurance company. It would be consistent with what he is recommending. So, they can certainly challenge this decision tonight to not hear it. And it would probably become part of the other lawsuit. Right now they're already asking the court to take a look at, what the town board did and what the plan commission did and determine whether or not that was appropriate. I've got my feelings on how that will go. I'm sure you can imagine what those are, but, so given all of that, I guess, we can discuss it more if you want to. I want to be careful about what we discuss, certainly because we're involved in a lawsuit.
Right.
So I'm going to be very hesitant to answer a lot of legal strategic questions or anything like that tonight. Like I said, my recommendation is that the board vote tonight to deny the request for the hearing because it's too late.
The nuts and bolts of this whole thing is basically to answer the questions is what, to the people, that should have been answered right from the very beginning, right? That's...
Roddy, yeah, there are a group of folks who obviously don't feel that the procedure was followed. They don't agree with the decision made by the Plan Commission, don't believe that the board and the Plan Commission spent enough time or looked at things correctly or considered the appropriate items. I understand that.
So basically it's a missing step in the process that was already taken that was never...
I don't think anything was missed.
As far as answering the
I
questions.
honestly don't, Rodney. We'll probably never agree on that one. But all I'm saying is just strictly from a legal standpoint. My job is to provide legal advice to this town board in given the lawsuit that is out there and other issues involving insurance and those types of things. My advice to you is to deny that. Now, if the circuit court takes a look at this and says, you know what, town of Bridgeport, you blew it. You didn't follow the procedure correctly, or Land Commission, you know what, there just weren't any rational basis for the decision that you made. And they will come back, the circuit court will come back and tell us that, and then we'll have to take a look at that. But given everything else that's going on, like I said, I'm not here for either, my job is to provide advice to this board. I would be doing my job if I didn't tell you that legally what I would tell you to do tonight to deny this.
Well, as the way I'm reading this and hearing it, we've already got a lawsuit against us because, or with the same amount of people that think they're aggrieved over this. My idea is to take it and deny the hearing, go to court with it, and see what the legal aspects are. So that's what I'm bringing up. Make a motion to deny the hearing.
It would be
Based on the time frame, and that's it.
This whole frac sand mining issue, that it's probably one of the most, I guess, controversial issues that the township has, I think, ever faced. In the birth of the state, really. We've never seen that. There's so many questions that all of the people of this township had. And we as a board, you have an obligation to answer the questions. Whether it was right or wrong, you have to answer the question, I know the board got, they got yelled at and screamed at, but, my gut feeling is, I think somewhere along the line they got screwed up. So, the hearing is really to answer the people's questions. That was promised by the board, right? It was promised, because I sat there before the elections, and I remember hearing, the board will answer the questions. it was promised, and it never got that far. So, my thought on it is that the mine had been approved, that's a fact, you know. But what I'm getting at is I think we need to do this right, you know. I believe, and let's do the process, let's set the hearing date and move forward on this. Do it for the people, they're the taxpayers, you know. So,
I remember sitting at several meetings for hearings, and we heard people talk, and heard it more than once. It was- People had a chance to speak.
I think John, proper, I mean, you got Mike's motion.
Okay.
You gotta see if there's a second, then you have discussion, and then, okay.
Okay.
We're discussing, I'm just saying, we're kind of discussing
All
it
right.
wrong. First you entertain the motion, then you entertain the second, and then we can discuss. So.
Well, I'll make a motion a second, Mike's.
Well, you don't have to make a motion, you just second it.
I'll second it.
Now, is there any more discussion?
yeah, I mean, we can talk about this for hours, I think, but, you know. And then another thing, I think, you know, the people should have had a chance to speak tonight, you know. Leave that up to the people. I mean, that's what we're all one. We're one big family. I think we need to, you know, listen to one another. We work for them.
Well, Todd, didn't we do the hearings right, proper? Did we forget something in the process?
I don't think you did, John.
What's that?
I don't think you did. I might, you know, the court may say otherwise, but I don't think you did. And I know folks might not have got the answers that they wanted to hear, or, you know, they may not have heard some of the things. But, you know, legally, they were given the opportunities they were required to be given.
So what happens with the questions then? I mean, there's so many things that people got in their minds. And if the board can't honestly have an answer right off the top of their head, you know, how does this affect this or that, or what does Bridgeport get from it, you know, stuff like that. How come not one person on this board can answer it? To any question that they would have spoken some time ago. They still haven't been answered. And that's what they're asking for is on the hearing. It's what I read in the letter, is that basically they want to, you know, their opportunity to repeat that step, that missing process.
But they were, I think they were given that opportunity, Ronnie. And I know you don't agree with that, and I know probably everybody in this room doesn't agree with it.
And I really don't. I don't agree with that. You know, I mean, we sat here that night, we had the meeting back to back. I believe you weren't here the first night. And it was said that everybody brought their questions to the table, and it was promised that the next night you would be here. Them questions would be answered. That next night, right off the bat, this wasn't open for the public, you know,
But
conversation.
a lot of the questions that were posed, and I don't want to go on and on about this, a lot of the questions that were posed were to be answered in the Plan Commission's deliberations. I mean, a lot of the questions that were asked were very similar to the findings or the issue, the findings the Plan Commission had to make. So that actually by, you know, when they discussed those things, a very difficult environment for those folks to discuss those things. But they looked at the findings that they had to make, and, you know, and they made their decision. And just about all of the questions I think that a lot of people had were centered around those findings. Again, in any event, that's.
So what if I, you know, off the top, just ask a question on that frac sand mine? Would anybody be honestly able to answer it here tonight? If I just started going off and just said, hey, how does it affect Bridgeport? I mean, what do we get out of it?
But that, well,
That's already been gone through over and over and over. As far as I'm concerned, you're talking, I enjoy the idea that you're talking your voice piece to this. But actually, where I look at it, your conflict of interest, even saying anything about it. You're on the board now, But as
Well, but
prior
Mike,
to
let's
it.
just, and I don't want to, I mean, everybody's going to scream, it's the lawyer, he's being
Sure.
technical, but I mean, what you have to consider, we're not really considering, we have to consider tonight is what you want to do with that appeal, okay? And that's what's before the board. So, I mean, you got a first, you got a motion, you got a second. I guess, John, you can call the question whenever you want.
I'll call the question, or roll call on the question.
Carter,
Yes.
Bishop,
No.
Steiner.
Yes.
Thank you. It's a motion to adjourn, John.
Motion carried.
Make a motion to adjourn.
I'll second that motion. All in favor, say aye.
Aye.
Opposed? Motion carried. We're adjourned.
I'm not, well, I guess it went to the town board, so yeah,
He said, that he already had that.
it's, yeah, it was,
You can take it home with you, I guess.
Important that we keep that around. I gotta have that back.
I'm just, once it goes to the town board, you can look at it.
Then it's public, yeah.
Yep, yeah, you can look at mine, yep. Had to think about that one. That lawyer stuff is hard stuff. That lawyer stuff's not easy. You can take one of those. I'm going to send each of the plaintiffs a copy, the electronic. But when I left, they didn't have them yet, which is, and so he has them now.